Hello, my name is Alice Kinder and I am a solicitor in the Employment and Pensions team here at Anthony Collins. I advise on all aspects of employment and pensions law and any issues that cross over the two. One of my particular focuses is advising organisations with staff in the local government pension scheme. In this webinar, we are going to look at the impact of two recent decisions of the Pensions Ombudsman concerning the ill health retirement of individuals in the LGPS. Whilst we are going to largely focus on the LGPS and the relevant tests under the LGPS regulations, I would say that some of the hints and tips coming out of the Pensions Ombudsman decisions will be relevant to organisations with staff in other pension schemes. By the end of this webinar, I anticipate that you will have enhanced your understanding of your obligations when dealing with ill health retirement cases, including the relevant timescales to be aware of. The LGPS, like many other pension schemes, allows members to retire before their normal pension age on the grounds of ill health or incapacity. In the LGPS, normal pension age is aligned to the state pension age. So the standard position, if an individual was retiring as normal, that would be at a minimum of age 65. Ill health retirement in the LGPS is open to active members, so those who are currently in qualifying local government service and making employee contributions to the LGPS. And it's also open to deferred members, so those who have left qualifying local government service but have not yet reached their normal pension age and are no longer making employee contributions. In order to qualify for ill health retirement, a member must meet some specified statutory criteria. The current criteria are set out in the Local Government Pension Scheme Regulations 2013. The criteria are worded slightly differently for active and deferred members, but broadly speaking, two questions need to be asked in order to make an assessment as to whether an individual is eligible for ill health retirement. Firstly, we need to look at that individual's capability of carrying out their local government role. The question that we are asking here is whether, at the time of making their ill health retirement application, the individual is permanently incapable of carrying out the duties of their local government role. If we are dealing with a deferred member, so somebody who was employed in qualifying local government service historically, we would be looking at whether they were permanently incapable of carrying out the duties of the historic role that they held. The second question that we need to ask ourselves is whether the individual is immediately capable of carrying out gainful employment. Now, by gainful employment, I mean employment for 30 hours a week over a period of not less than 12 months. It's important to note that this does not have to be the same type of employment as the individual has carried out when they were in local government service. It can be any type of job. So we need to ask ourselves whether, at the time of making their ill health retirement application, the individual is immediately capable of carrying out any job for 30 hours a week for not less than 12 months. It's worth noting that whilst I have just set out the current test, if we are dealing with a deferred member who was employed in qualifying service historically, the applicable test will depend on exactly when they left their local government employment. If they left before the 1st of April 2014, the applicable test will be set out in historic regulations, so those local government regulations that applied at the relevant time. If they left local government service prior to the 31st of March 2008, the applicable test will be that in the 1997 LGPS regulations. The reason I have highlighted this particular set of regulations is because in the 1997 regulations, the gainful employment test does not apply. So if we are dealing with this type of scenario, the decision on ill health retirement will just be based on whether that individual is permanently incapable of carrying out the duties that they carried out in their previous local government role. Before deciding whether to grant ill health retirement, an employer has to obtain a certificate from an independent registered medical practitioner, or an IRMP. This term is defined in the regulations, and essentially it means a registered doctor who is qualified in occupational health medicine. Once that certificate has been obtained, the employer must then reach their final decision, based on not only the IRMP opinion, but also other available relevant evidence. The employer's decision should be communicated to the individual in writing, so in a decision letter. This decision letter should clearly set out the reasons why the ill health retirement application is being granted or refused. Even if you think that you agree with the IRMP opinion and this is the basis for your decision, it's important to make sure that you don't just rubber stamp that opinion. The role of the IRMP is only to provide an opinion, and their role is not to reach the decision on your behalf. So you need to clearly set out in that decision letter why you agree with the IRMP's reasoning, and if there's conflicting medical evidence, so you've read another report that says something slightly different, why you prefer one set of opinions over another. So you might be thinking, where does the Pensions Ombudsman fit into all of this? If an individual is unhappy with the way in which their ill health retirement application has been considered, or perhaps they're not happy with the decision that has been reached, they can bring an appeal under the LGPS Internal Dispute Resolution Procedure, or the IDRP. This has two stages. For ill health retirement cases, stage 1 should be dealt with the employer or the ex-employer that made the decision to grant or refuse ill health retirement. It's important to note at stage 1 that an appeal investigation should be carried out by somebody who is independent from the previous decision that has been made. So somebody who did not have any involvement in the initial application. If the individual is still not happy after their stage 1 appeal, they can then bring an appeal under stage 2 of the IDRP. And this should be dealt with by the relevant pension fund. In both stages of the IDRP, a decision should be provided within 2 months of receiving the relevant appeal. It might be the case that a decision cannot be reached within 2 months. This often happens where, as part of the appeal investigation, we need to get a second medical report to assess the position fairly. In those cases, it is okay to reach a decision after 2 months, as long as you have written to the individual and let them know that there is going to be a delay in reaching the decision and set out when a decision is likely to be reached and the reasons why the delay has taken place. So, if an individual is still not happy after their stage 2 appeal, that is when they can bring a complaint to the Pensions Ombudsman. The internal dispute resolution procedure must be exhausted first. The Pensions Ombudsman deals with complaints of maladministration. This is a very broad term, and it covers things like bias, neglect, inattention, delay, or general incompetence. Complaints about ill health retirement pensions do make up a significant proportion of the complaints dealt with by the Ombudsman. When evaluating a complaint and making a decision on what is the best approach to take, the Ombudsman will look at a number of factors. They will look at the decisions that have previously been made about the ill health retirement application. However, having said that, what they are not there to do is substitute their view for the view of the employer. They will not be saying, I don't agree with that decision, I think something else should have taken place or a different decision should have been reached on the basis of the evidence, so I'm going to substitute my decision for that of the employer. Instead, what they'll be looking at is whether the decision was appropriate in light of the process that has been followed. They will look at the nature of the process that has been followed, the communications that have taken place, the evidence that has been taken into account, and then they will assess whether this means a different approach should have been taken. So, there have been two recent decisions on ill health retirement from the Pensions Ombudsman, which are very significant. The first case is that of Mrs. N, and this was decided by the Pensions Ombudsman in April 2019. So Mrs. N's case started in June 2014 when, as a local authority employee, she was diagnosed with breast cancer. In November 2015, so over a year later, she was told that the cancer had spread to her brain and that her illness was terminal. At this point, she immediately contacted the HR department at the council to request ill health retirement. Shortly after this, the council obtained two medical reports, which indicated that Mrs. N's life expectancy was in the region of 3 to 6 months. These medical reports were then sent to an IRMP to consider so that they could produce the relevant certificate. In the meantime, Mrs. N was given two quotes. One for a death in service pension, so if she were to die while still employed by the council, and the second for a death in retirement pension, so if she were to be dismissed from her employment on capability grounds and then to receive a pension and to die while she was a pensioner member of the LGPS. The death in service quote was lower. So taking the case on 2 months later, on the 12th of January 2016, the IRMP concluded that Mrs. N met the criteria for ill health retirement. On the basis of the available evidence, the council took the decision to approve the application immediately, but they set Mrs. N's last day of employment to the 31st of January 2016, so a couple of weeks after they reached their decision. However, Mrs. N sadly passed away on the 30th of January 2016, so the day before her employment was due to terminate, which meant that she had effectively died in service, so was entitled to the lower set of benefits that had been provided to her in the quote. Mrs. N's late husband brought a complaint about this, as he said that Mrs. N was not told when her ill health retirement application was approved, that if she died whilst in service, so in the 2 weeks before her employment was terminated, that she would receive the lower set of benefits. And on this basis, she didn't question the fact that she was to remain employed by a further 2 weeks after the decision had been made to grant her ill health retirement. The Ombudsman agreed with Mrs. N's late husband and held that, knowing she was terminally ill, the council had unnecessarily risked the amount of her benefits by keeping Mrs. N employed by a further 2 weeks after approving her application. The Ombudsman took a strict approach and ordered the council to compensate Mrs. N's estate with the difference in benefits. So the difference between the lower set of benefits that she had been quoted for death in service and the higher set of benefits that she had been quoted for death in retirement, together with interest. It also ordered the council to pay any tax liabilities to HMRC. A few months later, we get a very similar case of Mrs. I, which was decided by the Pensions Ombudsman in August 2019. Mrs. I's case started in September 2015, when she, as another local authority employee, was diagnosed with advanced cancer. She commenced sick leave a month later, in October 2015, and according to the council's policy, she received 6 months of full sick pay and 6 months of half sick pay. So Mrs. I's sick pay ended a year later, in October 2016, but at this point she had not recovered and continued to be off sick. The council didn't assess her for ill health retirement until June 2017. Following an IRMP report, The council did then write to Mrs I and advise that they would dismiss her on capability grounds with effect from the 31st of May 2017, meaning that her pension would be paid from the 1st of June 2017. However, there was then another delay, and the council didn't process Mrs I's pension and put it into payment until February 2018. This meant that from April 2016, when Mrs I's sick pay was halved, until February 2018, when she received her pension, she was without a full income. A complaint was brought, and this went all the way to the Pensions Ombudsman, and the Ombudsman agreed with the complaint. They found that the council's failure to take appropriate steps before the end of Mrs I's sick pay to ensure that her ill health retirement pension came into payment once her sick pay entitlement had expired was tantamount to maladministration. They said that Mrs I was left without pension provision from October 2016, when she should have really started receiving it, until February 2018. And the 7.5-month delay before assessing Mrs I for ill health retirement was inappropriate. The Ombudsman said that had the council taken an appropriate process and taken steps to assess Mrs I for ill health retirement in a timely manner, so when they knew that her half sick pay was coming to an end, her pension provision would have been available as soon as her sick pay expired. The Ombudsman said that in the context of ill health retirements, the role of the employer begins a very long time before employment has been terminated, and the question of entitlement to an ill health retirement benefit arises. So, what can we learn from these two decisions? The first point is that it is very important to be proactive. A key point that was raised by the Pensions Ombudsman is that employers should be proactive in initiating the ill health retirement procedure where this is appropriate. It is very likely that an individual who is seriously ill will be preoccupied with their own health and will not really be giving much thought to whether or not they should write to you and request ill health retirement to be considered. If you know that an individual who is a member of the LGPS is seriously ill, you should be giving some thought to the stage at which it might be appropriate to start considering ill health retirement as another option. If you do receive an ill health retirement application, it's important to make sure that you are dealing with this in a timely manner. When you receive this request, you should be ensuring that you are taking prompt steps to initiate the relevant investigations and to make sure that a conclusion on the position can be reached within an appropriate timescale. The Pensions Ombudsman has really emphasised in these two cases that a failure to understand the urgency behind processing ill health retirement can have a significant impact on an individual's already ill health. And in this case, they might consider that the individual has suffered from distress and inconvenience, and they can award compensation for those things. If you do reach a decision to grant ill health retirement, you should make the relevant arrangements to ensure that the pension is paid promptly. This will mean making the pension fund aware that you have reached a decision and potentially also notifying your payroll team. The second point is that it is important to be prepared. This means maintaining awareness of employees who are on long-term sick leave. If you have individuals on long-term sick leave, you should be keeping in regular contact with them to maintain an up-to-date picture of their illness. And by doing this, you should hopefully be prepared and have an idea of when it might be appropriate to start thinking about ill health retirement. In Mrs N's case, the Ombudsman said that the council should have been inquiring about Mrs N's deteriorating illness so that they knew when ill health retirement should start to be considered. What I would suggest here is that you keep a record of when individuals have been contacted and diarise when the next follow-up is due. In addition to this, I think that you should also maintain a clear file of communications and relevant evidence. So this will ensure that you're prepared and have the relevant information to hand when you start considering ill health retirement. As I've already mentioned, you will need to consider all available medical evidence, so the IRMP report and any other evidence, before reaching a decision to grant or refuse ill health retirement. You can be prepared for this by requesting copies of medical records at an early stage. This means that if the ill health retirement process needs to start, or if this needs to be dealt with particularly urgently, you will have the relevant medical information to hand, and you won't be delayed waiting for these records to arrive. If you instruct an IRMP, they will usually want to see all of the available medical records before preparing their certificate. So we need to make sure that they are not being unnecessarily held up in reaching their decision and preparing their report because the medical records still haven't arrived. If you are faced with a Pensions Ombudsman complaint, it's likely that the Ombudsman will write to you and request further information from you, or potentially a statement of your position. If this happens to you, it's important to diarise the deadlines the Ombudsman has given you to respond. If you think that you're not going to meet the particular deadline that you've been given, and sometimes these deadlines are only a couple of weeks, I would recommend that you write to the Ombudsman and formally request an extension, and make sure that any extension has been given to you in writing. In one of the recent cases that we've just discussed, the Ombudsman actually highlighted that a council who had failed to take account of these deadlines that they'd been given by the Ombudsman was only showing that they had not taken the whole ill health retirement process seriously, and that this particular approach provided evidence that they had not treated the relevant individual with the degree of respect that was due. The final point is that it's important to be practical. This means considering the wider context of the situation. In the Mrs. I case, the Ombudsman emphasised that it should never be assumed that an employee who is on long-term sick leave is not eligible for ill health retirement until their sick pay expires. In reality, employers should take a practical approach and think about the fact that Mrs. I or any other individual in the same position is unlikely to be considering ill health retirement themselves. And so the employer should be taking practical steps to initiate the process so that the pension is ready for when that individual's sick pay expires. We also need to be practical in our communications. These should be clear and accurate and concise, and take into consideration the fact that a member may have other things on their mind, most likely their ill health, and also that they might have limited pensions knowledge. So if we are faced with the type of situation that Mrs. N faced, where there might be a death in service quote versus a death in retirement quote, or any other similar pensions jargon, we need to make sure that we are explaining these points clearly to the individual so that they understand the impact of the potential decisions that they make. A final point to note is that if you have an employee who is on long-term sick leave and you are considering dismissing them on capability grounds, a failure to properly consider ill health retirement could render that dismissal unfair. So there has been quite a bit of previous case law on this point, and this has held that for a dismissal to be fair, an employer must take reasonable steps to ascertain whether that employee is entitled to benefit from an ill health retirement pension before taking the final decision to terminate their employment. So it's important to be practical in this respect to ensure that you're not facing an unfair dismissal claim as well as a Pensions Ombudsman complaint. So I hope that has been helpful in clarifying the points that you need to consider when dealing with ill health retirement cases. On the basis of the two recent decisions we have talked about, the Mrs. N decision and the Mrs. I decision, I think the Pensions Ombudsman is likely to continue taking a strict approach to any delays and negligence when dealing with ill health retirement. You should therefore remember the 3 Ps that we have just talked about, being proactive, prepared and practical, and review your procedures to make sure that ill health retirement scenarios are being dealt with appropriately. If you do have any queries arising from this webinar that you would like further advice on, then please do feel free to contact me using the details on the slide. My personal contact details have been included on the earlier slide, and there are also some contact details on this side, So please do feel free to get in touch. Thank you very much.